Item number 17, my lord. I have been engaged in this case by the appellant number 1 recently, my lord. I seek some time, my lord.
How much time you want?
2 weeks, my lord, if possible.
But it may be fixed in next week, my lord. We are not on bail. The other accused are on bail. I am appearing for accused number 4 in the appeal. If I may pray for listing the matter next week, any date, my lord.
28. Was it 28 May?
I'm obliged, my lord.
Lordship,
Yes.
Lordship, I am for the informant matter. Lordship, 28 will be difficult for my senior man.
28 तारीख को से.
28, it will be difficult. On any other date, madam?
29th.
29th, yes.
Take down Mr. N.J. Datta, learned counsel, has appeared and submitted that he has been recently engaged as the counsel for the appellant number 1 and therefore 2 weeks time to prepare and argue the matter. Mr. S. Biswas, learned counsel for the other appellants, has expressed urgency in the matter on the ground that his clients are not on bail. Ms. B. Bora, learned counsel for the informant, is present. Having heard the learned counsel for the parties, we direct the registry to list this appeal again on 29/5/2024 as a fixed item for hearing. Yes.
I'm obliged.
Much of this.
It will available, Ms. B.
May I please, your lordship, I beg to mention item number 7, lordship. Kindly adjourn the matter for the day, lordship. Senior counsel H.R. Chaudhary is out of station, lordship. And conducting counsel also out of station.
It's paid for by the appellant's counsel, which matter stands adjourned for weeks.
Obliged, lordship.
May I please, lordship? My lord, item number 15. I am praying for adjournment of the matter for today and may kindly be listed in the last part of this month, lordship.
No, we'll adjourn it for 2 weeks on the prayer of Mr.
Lordship,
Emmanuel,
any date
learned
28,
counsel for the
29, 30.
applicant appellant, this matter stands adjourned for 2 weeks, list accordingly.
Obliged.
Daily list for admission item 1.
May I please, your lordship?
Yes.
My lord, this is an appeal against a judgment on 16/12/2000. My lord, and this is an appeal, my lord, appellant are accused number 2 and 3, my lord. Sentencing them under section 302 life, my lord. And my lord, here in this case, my lord, while deciding the impending judgment, my lord, that 2 witnesses are their wife and daughter, PW1 and PW6, my lord, and PW2 also important, my lord. But while delivering the judgment, my lord, in PW6 daughter and PW2 has said that Ramzan Ali has killed the accused number 1 has killed the victim, my lord. But we just have rule of the appellant number 1 is that he getting out the bhujali from his stomach and he's just taking the dead body. This is the only allegation. Second, but all this eyewitness and PW this evidence has not been discussed here, my lord.
We'll admit it.
Yes.
But Mr. P.K. Dekkal, as counsel for the appellant, also heard Mrs. Jahan, learned LLB Assam appearing for the state. This appeal is directed against the judgment and order dated 16/12/2023, passed by the learned session, District and Sessions Judge Kachar, in Sessions case number 125 of 2000, whereby the appellants have been convicted under section 302/34 of the IPC and sentenced to undergo rigorous imprisonment for life and also to pay a fine of rupees 10,000. Wherein each of the appellants have been rigorous imprisonment for life and also to pay fine of rupees 10,000 with default stipulation. We have perused the grounds taken in the memorandum of appeal, admit the appeal, call for the LCR, issue notice returnable in 4 weeks. Since Mrs. Jahan, learned APP Assam has appeared on behalf of the state, no formal notice is required to be sent in this case. This case after receipt of LCR.
My lord, here is the IA, my lord, for stay on bail, my lord.
So we'll
After
consider it.
receipt.
Yes. And Mr. P.K. Dekkal, our counsel for the applicant, also heard so-and-so for the state. This IA has been filed with a prayer to pass, this IA has been filed under section 389 of the CRPC with a prayer to suspend the jail sentence of the applicants and also to release them on bail. The prayer made in the IA shall be considered after receipt of LCR. The state may, in the meantime, file objection in the matter if so advised.
Leave locus.
Item 2.
Wait, please, Your Lordship. My lord, it's a appeal, my lord. Appellant was, my lord, convicted by 30 years, my lord, under section 6A of, my lord, POCSO Act, my lord. So, my lord, let the matter be admitted, my lord, and exam may be called for, my lord.
All right,
Notices will go to the victim.
right. But Mr. K. Burwal and counsel appearing for the applicant, this appeal has been preferred against the judgment that was dated this 6/2/2024 passed by the Court of Special Judge, Jorhat, Assam, in special case number 15/2019, convicting the appellant under section 6 of the POCSO Act 2012 and sentencing him to undergo rigorous imprisonment for 30 years and also to pay a fine of rupees 10,000 with default stipulation. We have perused the grounds taken in the memo of appeal, admit the appeal, call for the LCR, issue notice returnable in 6 weeks since Mrs. Jahan, non-deputy Assam, has appeared and accepted notice. On behalf of the state stroke respondent number 1, no formal notice is required to be sent to the state respondent. Appellant to, however, take steps for service of notice upon the respondent number 2 by registered post with the AD within a week from today.
And there is a IA, my lord, notice may go in the IA also, my lord.
The IA writes so and so for the applicant, so and so for the state. Rest is same. and
Right.
For order, item 3. 3 to height.
Wait, please, my lord. My lord, will see the last few orders, my lord.
Item 6.
In this matter, I was supposed to get instruction whether notice is served. I spoke to the OC Borpata. He has served the notice. He had sent me an intimation, Lordship will be surprised. On the page of the cause title, he has taken the signature of the informant. And I've told him, send me the notice that you have apprised him of all the facts. He said he'll send it, but till now he has not sent. Lordship will see that he has taken his signature on the cause title of the, and he has said he has informed. That he has said. He has taken the signature of Dilip Mondal. Now, ki ho? Dilip Mondal, no? Milan Mondal.
No, but where is his report?
Yes, that
Okay,
he
we'll
will.
give him 7 days, failing which he will order personal actions.
Lordship, I'll get it from him.
Heard Mr.
Ahmed.
HML and counsel for the appellant. Also heard Ms. S. Jahan, learned APP Assam, appearing for the state, who submits that pursuant to the order of this court, the officer in charge of Barpeta Police Station has apparently served the notice upon the respondent number 2, but the said officer has failed to forward a report in proper format. Ms. Jahan submits that she has only received copy of a document, which is the cause title of the appeal, wherein the signature of the respondent number 2 in acknowledgement of receipt of notice has been shown to have been ascribed, full stop. Admitting that the same is not a proper procedure for responding to the court's order, Ms. Jahan seeks posting of this matter again after a week so as to enable her to complete the necessary formalities. We make it clear that if the officer in charge of Barpeta Road Station fails to respond to the court's order in an appropriate manner, this court will consider directing personal appearance of the officer.
Lordship, no blame.
A copy
Date
of
may
this
be
order
fixed,
will
ma'am.
furnish to Ms. S. Jahan, learned APP also.
Date may be fixed, my lord.
Yes, after 1 week.
Item 8.
May I please your lordship? In this case, notice served, sent for the respondent number 2. No, Sarvijipur is still awaiting, my lord. There is the order of the honorable court to just sent through OC.
We'll get the instructions today.
Another 10 days, Mr. S.C. Biswal, when council is present for the appellant. On the request of Ms. S. Jahan, learned APP Assam, we adjourn this matter for 10 days so as to enable her to obtain service report from the concerned
POC.
officer in charge. From the officer in charge of Runikata Police Station. Not concerned, huh? Officer in charge. Let the matter be listed accordingly.
Timing letter, item 3, 4, and 5.
I'm sorry, lordships. I have communicated her, but she said that she will not sign agreement,
All
lordship.
right. We'll post it for hearing then.
Well,
Heard Mr. B.D. Dekal and council. Also heard Ms. R.B. Boran and council appearing. For Mr. B.D. Dekal and council for the appellant appearing in item number
7 and 8.
7 and 8. Also heard Ms.
I'm sorry, matrimonial appeal 7 and 8. my lord.
4 and 5. Item 4 and 5. Also heard Ms. R.B. Boran, Planet Legal Aid Council, who is appearing for the respondent in both these appeals. Full stop. There is the order dated 6/5/2024, passed by this court. Ms. Bora submits that despite necessary communication sent to the respondent bracket Y, she has refused to sign the compromise agreement. If that be so, these matters will now have to be heard and decided on merit. Therefore, register to release these cases for final hearing after 3 weeks.
Deeply obliged. lordship.
Along with item 3. Along with item 3.
Deeply.
Item 9, 11.
May I please? Your Worship? Also, this is a criminal appeal, there's a miscase. or
Lordship,
suspension of-
10 and 11, I have filed my objection. And 9, I'm told someone has filed. May I get a copy of
PP officer only file.
objection on detail? Listen here, but. Yes.
Copy, yes, sir.
Yes, please.
So, my lord, in this case, my lord, there are altogether 5 persons. 6 person has been convicted. I am one of them, my lord. Against me, my lord, there is only evidence of 1 phone call, my lord. Apart from that, there is nothing, my lord.
Convicted under 302.
It's under 302. What happened, my lord? One girl and 1 boy, they have been caught red-handed in an inappropriate position in somewhere. Then some boys has apprehended them and they have started demanding money from them, from the boy basically. Then the girl was let go, then the boy was kept and subsequently he was found dead. Nobody has seen, my lord, but these persons were there at the time. I was not there in the place of occurrence. Then the only one evidence is that during that time, that there's a phone call came to me. And the phone call also, there's some conversation, but we don't know what is the conversation. And on the basis of that conversation also, I have been convicted. And I am also a part of this group, my lord. On my instruction, it has had happened. So, but the phone call does not implicate anything, my lord. Rather, it is seen from the evidence and record that the boys who were present at the place of occurrence, they are also demanding money from me also. That's the evidence, that's the PW1.
So you are in item 10 and item 11.
9,
You are in item 9.
yes.
Let us see where is item 9. Are you? One. Yes. Lal Mahmud Khan, is it?
Yes, madam. The
And what about the other two cases? Who is appearing?
I'm for 11, my lord. PW1, my lord. She is the vital witness. She is the lady who was also. She is the lady who was apprehended by that particular group. 165. Now, Lordship, before that, my lord, Lordship kindly turn to page 142, my lord.
142 of your IA.
Yes, ma'am.
Yes.
Page 42, my lord. Ramina Khatun, my lord, this is the PW1 and this is her 164 statement, my lord.
Yes.
I have appeared on the matriculation examination. So for 3 years from today, I am in a love relation with the Rubul Haq. Rubul Haq is the deceased, my lord. Chaudhary, and we met each other from time to time. Injamamul Khan, Darogali, and Saiful Islam from my village had given me love proposal, but on my refusal to accept their proposal, they threatened me that they would not allow me to marry anyone else. On 16th 2022, at around 12 p.m., Rubul invited me to meet him at the bank of Bandali River, and I took my sister Bimala Khatun with me. When I was talking to Rubul on the bank of the river, Injamul Khan, Darog Ali, Saiful Islam came over, and for no reason they altogether started beating Rubul. When I cried and cried to obstruct them, they together pulled my hair and started beating me. When they were beating us, Bacha, Aminul, Faridul from the village and few more people gathered there. At first, Bacha, Aminul and Faridul obstructed Rubul from getting beaten, and then the rest of the people went away. Now, Lordship, can you see? At first, Bacha, Aminul and Faridul obstructed Rubul from getting beaten. And then the rest of the people went away. They, along with Injamul Khan, Darogali, and the Saiful Islam, demanded. Now, all of them demanded 3 lakhs of rupees from Rubul. And when he stated that he could not pay, then they again started beating him. They broke his tooth and hand and inflicted several injuries on his head, ear, chest, and the back, and threatened him for if he could not give the 3 lakhs of rupees. Thereafter, Batsah called Lal Mahmud Khan, this is me, over phone and asked for 3 lakhs of rupees. So, this Batsah also called me and also demanded 3 lakhs rupees from me. Meanwhile, Jainal came to the place of occurrence and he requested Injamul Khal, Darogali, Batsah and others to not to beat Rubul and told us to leave the place. My sister and I came with the Jainal to our house crying and they told everything to our parents. Later, my family members went to the search of the Rubul to the bank of the river and they heard from the others that Rubul jumped into the river. Rubul by himself had not jumped into the river. I suspect that he was thrown into the river by Injamamul Khan, Darogali, Saiful Islam, Bacha, Amirul, and Faridul. So that is the only evidence against me that this Bacha called me and also demanded 3 lakhs rupees from me. Now, this is the PW1. His deposition is page 52. Her deposition is 52. Now, paragraph 3, page 52.
Yes.
On a day of occurrence, this is Rubul, paragraph, called me into the meet him near river bank at the Bandali. At Baitha, raised hand so and so. I bank of the river. I accompanied my sister Bimala Khatun and friend Taslima alias Josna. Taslima and Bimala were at the distance of seeing the accused Injamul there. Taslima returned, Bimala also standing at a distance from the Baitha. Rubul was already in the Baitha and went there and conversing with him. At the time, accused Injamul, Darogali, and the Saiful started assaulting Rubul for no reason. They had punched the deceased, they had fractured the hand of the Rubul. They had also punched me in the face and pulled me by hair. They had also pressed my neck. Injamul, Darogal and Saiful used to love me and they had proposed me to become their girlfriend, but I refused it. They had also threatened me they would not allow me to get married with other. They did not bear the fact that I was in love with relation with the deceased Rubul. When the accused Injamul, Darogal and Saiful had beating me, deceased Rubul accused Faridul, Badsha and Aminul came there and accused Faridul has slapped me. Meanwhile, many other villagers also assembled there. When the villagers had slipped away, all the 6 accused persons had started demanding rupees 3 lakhs from Rubul. So these accused persons actually started demand. And as they claimed that they was indulging in indecent act with deceased Rubul, Rubul replied that how could he pay rupees 3 lakhs to them at the time. When the accused person snatched away the key of the Rubul's motorcycle, so and the mobile phone of him, at that time, Badsha called Lal Mahmud again, my lord, over the phone and asked his opinion as to what they would do with us if they claimed that they had beaten and caught red-handed while indulging in indecent sexual act. Lal Mahmud had advised Badsha to ask for rupees 3 lakhs. This is now contradictory to the 164 from the Rubul. Rubul refused to pay the amount. The Lal Mahmud then directed the accused person to kill Rubul if he could not pay the amount. This is a conversation between my lord Badsha and Lal Mahmud. How she came to know about this conversation is surprising, my lord. And in 164, her categorical statement is that it is the Badsha who has demanded money from the Lal Mahmud itself. So this is the development she has made in the deposition, my lord. That's all, my lord. Now, Lordship, kindly see the cross part in page 57.
Yes.
Paragraph 24 onwards, my lord. This is important. I told police that the accused Badsha called Lal Mahmud and asked 3 lakhs and non-payment of the said amount Rubul would be killed. So that contradiction been proved. In the chief, she has said that I demanded 3 lakhs from the Badsha, whereas in the 161, her statement is otherwise. It's a corroborative statement with 164 statement. That rather the Badsha, he also demanded rupees 3 lakhs from me.
So what is the material to convict the applicant?
This is the material that I
Where
have
is the
failed to
finding-
discharge.
Where is the finding of the trial court?
The discharge under 106 of the Evidence Act. That's the only evidence that why I have failed to discharge. What is the phone call? What is all about? So this is the only evidence, my lord.
There is no 106 here. Where is the finding of the trial court?
Finding of the trial court, my lord. Paragraph 159 and page 103. Page 137 is the main. Paragraph 165.
What is the page number?
Page 337. In our page 117, paragraph 165 onwards. If we link the dots left by the prosecution evidence, it emerges that the well-knit conspiracy was hatched by the accused person. At first, PW1 was being assaulted by PW1 to 3, accused 1 to 3, and thereafter 5, 6, 4. Aminul entered in the scene, but the 4 Aminul left the scene of the crime. PW1 was taken back by his cousin PW3 Jainal. CDR corroborates the version of the PW1 that PW6 was conversion with PW accused 4. Accused and taking instruction regarding the money demanded 3 lakh. The inability to learn a defense side to probabilize what was the content of the discussion between accused 4 and 6. That is the Lal and me. In fact,
Yes,
stultifies.
Lordship,
What is your response?
Lordship, PW1, the girlfriend of the victim, Your Lordship. PW 1, 7, 11, and 13, specifically, Lordship name, the involvement and the role played by the accused person. This person, Lal Mahmood, my lord. Lordship, may I take to the evidence of PW1, my lord?
Since there is some contradiction.
Lordship, I don't have the LCR, can I say? From my objection, I'm reading, my lord. A4 Badshah and A6 that Lal Mahmood, my lord, called over phone and discussed about the fact that what should be done with deceased Rubul, and PW1 as they claimed that they had been caught red-handed while indulging in indecent so and so. Then, Your Lordship, A6 Lal Mahmood had advised A4 Badshah to ask for 3 lakhs from Rubul, but the deceased refused to pay the amount when A6 directed A1 to A5 to kill Rubul if he did not pay the amount. So he directed, Your Lordship, the involvement of A6, my lord. Lal,
Where is the evidence on that?
Lordship, may. Lordship, may I read paragraph 6 of evidence of PW1. When accused Inzamul Darok Saiful had been beating me and deceased Rubul, accused Faridul Badshah and Amirul came there and accused Faridul had slapped me. Meanwhile, many other villagers had assembled there. When the villagers had slipped away, all the 6 accused persons had started demanding rupees 3 lakhs from Rubul, as they had claimed that I was indulging in indecent act with deceased Rubul. Rubul replied that how could he pay rupees 3 lakhs to them at that time? When the accused person snatched away the key of Rubul's motorcycle, R15, and the mobile phone of him. At that time, accused Badshah called Lal Mahmood over phone and asked for his opinion as to what they would do with us, as they claimed that he had been caught red-handed while indulging in indecent sexual act. Lal Mahmood had advised Badshah to ask for rupees 3 lakhs from Rubul. Rubul refused to pay the amount. Lal Mahmood then directed the accused person to kill Rubul if he did not pay the amount.
See, the point here
Lordship,
is,
yes.
just a minute, we are putting things in perspective.
My lord.
At the moment, we are only on the
Interlocutory
application
application.
of the present application.
Lordship.
When we move on to the other matters, we'll go. So the applicant's counsel is saying that the only basis to implicate him, this conviction is 302 read with, is there conspiracy angle?
Conspiracy.
Which provision? 120? 120B. All right. So the basis is that there was a phone call. Phone call is not denied. But the prosecution version is that by the phone call, one of the accused asked the applicant as to what should be done. The applicant says, ask for 3 lakhs and release. That's the prosecution version. For the time being, it's binding on the prosecution because the prosecutrix has herself stated this in 164 and in cross-examination, there is corroboration of the 164. Now, if her version is taken to be correct, then the applicant says, ask for 3 lakhs and release. So it could at best be a case of ransom, but there is no instruction to kill him. So where's
No.
the question of 33302?
Lordship, but thereafter your lordship may kindly have a look. From my objection, I'm saying
Yes.
the involvement of accused person, PW 711 third. May I take your lordship?
You take the assistance of your objection,
Yes.
but we will look at the
Yes,
evidence.
yes, my lord. PW 7, 11 and 13.
All right. Where is the Badshah is accused number?
Badsha Fakir,
You are appearing for Badshah.
4.
item number 11.
And,
A4.
A4 and this person.
A6.
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 Yes.
As per evidence of PW 7, from the evidence I'm seeing, the occurrence took place so and so,
PW7 is page.
from LCR I'm seeing.
82. 82. In my petition, my lord, 82.
PW 7 is named, this present applicant.
Yes.
Faridul Inzamul Saiful Badshah Fakir, Lal Mahmud Khan and Darogale Elas Jakir had assaulted my brother in Romania and demanded rupees 3 lakhs from my brother. After assaulting both of them, the accused person then called Rumena's brother and handed over Romena to her brother. But the accused persons kept my brother confined with them, stating that his guardian would come. Lal Mahmud had kept confined my brother and told that my brother's guardian would arrive, and as such he kept him in his custody by brother. After that, they killed my brother and failed him in the river.
She is an eyewitness to the occurrence.
No, no, no.
How does she know all these things?
See, here's the first line. It's Lordship, can you see page 86, paragraph 16? Cross, my lord.
Yeah, just a minute. Ms. Bhuya,
My lord.
what is the probative value of this evidence?
May I see whether he is a direct evidence? I think he is not the eyewitness.
Then
There are only 3 eyewitnesses, 4 eyewitnesses, my lord. 7 is not an eyewitness. Page 86, my lord. Para 16, Lordship can see.
and what does it say in his
Lordship, and,
313? This accused A6. What does it say in his 313? What is this 313?
This accused
A6.
person, A6.
There is only one incriminating circumstance which could have been and ought to have been put to him.
Roshi, I think because there, in cross-examination, he reiterated, I asked accused Faridul and Lal Mahmood that we were ready to meet their monetary demand if they brought out my brother, if they had kept him confirmed somewhere. Faridul and Lal Mahmood had told me that Saiful Darog, Inzamil and Badshah Fakir had assaulted my brother more. Then in 313, Lordship, may I see?
It's 11 কি question?
Because there was a Lal Mahmood.
Yeah, see. Yes, sir. Lordship, can you turn to page 86?
All denial, my lord. Nothing has come out. From Lal Mahmood. Mere denial, my lord.
Yes. Which Bhuya.
I'll just read out only.
Normally, the principle which we follow in this court on bail. Bail is to be
Prima
granted
facie,
in
my
first
lord.
5-10 minutes,
Yes,
either granted or rejected.
yes. 11 and 13, may I see once? Just,
Show us that.
yes.
That's all. There will be 1 or 2 points to
Yes,
either
my,
grant or
yes, my
reject. the
lord.
bail.
If they,
We're not going into a detail.
lordship,
analysis.
lordship. Only 11 and 13.
Yes. A bail application should not take more than 10 minutes.
Yes.
11 and 13, my lord. Not a whisper about me.
Let her please.
Let her read, my lord, if she can find it out.
11, 13. Which are the page numbers?
From the LC.
From my Lordship, can you say page 98, 11?
PW 11, Abdul Rauf Ahmed. On being called, Badshah told me that
Please
one,
take us to the relevant part.
yes, ma'am.
What do you want to say? Why don't you be very blunt? What is the point to deny him bail?
Lordship,
Yes.
as he is submitting, as my learned senior friend is submitting, then only involvement, his role is that he was called and he told to settle the matter at 3 lakhs. Apart from that, whether any other involvement of
Yes.
the present accused person is there, present convict is there.
You prepare for the hearing.
Lordship, I leave it
But
alone.
Mr.
So what about the other accused person?
Other will pass an order when we take it up.
Yes,
Right now it is only in IA criminal
my lord.
1111 of 2023. Take down heard Mr. M. Boral and his senior counsel estate by Mr.
V. H. Chaudhary.
H. Chaudhary, learned counsel for the applicant. Also heard Miss B. Bhuya and his senior counsel and FPP Assam assisted by Miss M. Chakraborty appearing for this case. None has appeared for the installment. The applicant hearing was one of the 6 persons who were convicted under section 302 public 120B of IPC and sentenced to rigorous imprisonment and sentence in an inter alia sentence to rigorous imprisonment for life and also to pay fine by the impugned judgment and order dated 14/9/2023. Passed by the learned additional session judge bracket FTC bracket close Borpeta bracket Assam in connection with sessions case number 160/2022. Convicted under 120B stroke 385 stroke 323 stroke 354 stroke 302 of the IPC. Right. Since then, the applicant is in jail. First up, by filing the instant application, the applicant has paid for suspension of his jail sentence. The applicant, namely Lal Mahmood Khan, has paid for suspension of his jail sentence and also to release him on bail. Stop. By referring to the materials on record, Mr. A. M. Bora, learned senior counsel for the applicant, has argued that his client had no involvement in the incident, but the learned trial court has convicted him only on the basis of an alleged phone call made by one of the co-accused to the applicant. According to Mr. Bora, even the phone call, according to Mr. Bora, as per the evidence led by the prosecution, the phone call was merely addressed to the applicant to find a solution to the problem whereby the applicant had asked the alleged assailants to release the victim on payment of some amount. Full stop. Under the circumstances, Kumar submits Mr. Bora, there is no justifiable ground to convict the appellee on any of the charges brought against him. Full stop. In support of his above arguments, Mr. Bora has taken us to the 160 to the statement of the PW1 bracket PW1 recorded under section 164, as well as her deposition before the court to point out the inherent contradiction in her evidence. Full stop. We have also been the attention of this court has also been invited to the evidence of other witnesses, namely PW 7, 11, and 13, to contend that there is not even an iota of evidence against the applicant to sustain the conviction. Full stop. Responding to the above, Ms. B. Bhuya, learned APP Assam, has argued that the PW1 has categorically stated about the phone call made by accused Badsha, bracket A4, comma, bracket close, to applicant Lal Mahmud Khan, bracket A6, and therefore there is no infirmity in convicting him on the basis of such evidence available on record. So we have considered the submissions made at the bar and have also gone through the materials available on record. First up, from the testimony of AW1, who is the girl who was found along with the accused in an allegedly compromising position, which had led to the commotion, whereby the accused persons had allegedly threatened the victim, Rubul, and ultimately committed his murder. First, from the statement of PW1, we find that although she had initially stated that Badsha had made the phone call to Lan Mahmud to seek advice as to how to resolve the dispute, later on, she had changed her version by suggesting a sinister act of Lal Mahmud. However, during her cross-examination, the PW1 has resiled and corroborated her version given in the 164 statement, which exonerates the applicant from the charges brought, which practically exonerates the applicant from the charges brought against him. Whether the materials on record are sufficient to establish a charge of conspiracy under section 120B of the IPC would require a detailed hearing, which would be possible only at the stage of final hearing of the appeal, on a preliminary appreciation of the materials on record. We are of the prima facie opinion that the evidence available on record are insufficient to establish the charge brought against the applicant. First, in view of the above, we are of the unhesitant opinion that the applicant has made out a good case for granting his prayer made in the IA. Full stop. We accordingly direct that applicant Lal Mahmud Khan, alias Mahmud, be released on bail on furnishing a bond of rupees 50,000 and one local surety of like amount with the satisfaction of the learned assistant, whatever that additional session judge, FTC. Borpeta, bracket close, Assam. Full stop. In addition to the above, it will be open for the learned additional sessions just to impose any other additional condition for release of the applicant on bail. Full stop. Before parting with the record, we make it clear that our observations made herein above are tentative and have been made purely for the purpose of disposal of the IA. Full stop. Such observations shall not have any bearing at this stage of final hearing of the appeal. I step forward.
Well, order dated 14/9/23 has to be suspended, my lord.
We have asked him to be released on bail. That's it. Released on bail. Consequently, the order dated
14/9/23
14/23
in respect of the accused petition.
imposing sentence upon the accused persons sentenced shall stand suspended qua the applicant Lal Mahmud.
Yes.
Yes. next.
May please, your lordship.
Yes.
Well, though I have filed a IA for the bail because the prime accused is 1, 2, and 3. So I prefer that the paper book may be ready and we can hear it man at length because the main accused are 1 and 2 and 3. That's why.
After arguing the matter for some time, Mr. K. Bhattacharya, learned counsel for the applicants, submitted that instead of pressing this IA, he would request this court for early hearing of the connected applicant. First, therefore, Mr. Bhattacharya prays for an order of the court to expedite preparation of paper book. Mr. The said submission has not been opposed by Ms. B. Bhuya and it appears some appearing for the state. In view of the above, registry is directed to expedite the preparation of paper. LCR has been received.
Yes.
Let the matter be listed for orders after 3 weeks with appropriate office note. The IA is kept pending and shall be considered at an appropriate stage. Yes.
Oh, less. Lordship.
But before proceeding, my lord, can I
Same order.
point out here, my lord, for IA is there, my lord.
Similar order in which one? Previous one or the one before that?
Oh, no, my lord, the earlier,
Previous one or subsequent one?
subsequent one, my lord.
For hearing.
Subsequent one.
No, my lord. But
Early
I'll
hearing.
go in between, my lord. I'll make a
Early
try.
hearing.
I'll make a try in between road, my lord.
In between is dangerous.
Because there is no eyewitness in this case, my lord, actually. But the judges, the trial court just took 3 persons' account as an eyewitness account, my lord, and thereby convicted, my lord. Probably himself got misled, my lord. That there is no eyewitness. They have nobody has seen anybody killing
Maybe
anybody.
right, but
So
Bail
give
for
me a
bail.
chance, my lord. Next week, my lord, I'll try to make a submission, my lord.
next week. You want
Or on Friday, my lord.
to get an early hearing?
My lord, let me have a chance, my lord. It's always there, my lord.
The prayer of Mr. Z. Kamal and counsel for the applicant. His IA is directed to be listed again after a week. His BVL and
On Monday, my lord. Mr.
present on bail state.
You want to
Next week.
next. That will do, my lord. Much obliged.
Okay, sir, no?
May I please, your lordship?
Yes.
3 persons, 3 appellants are convicted under section 302, your lordship. The IA is for their bail, your lordship.
How many applicants?
3, your lordship. 3.
So, Mr. Borthakur, the rule in this court is same.
Lords.
If you don't make out a case for bail in 7 minutes, then you
Lords.
know that you are not getting it.
I will try, your lordship.
5 to 7 minutes.
Lords.
What are the pinch point?
Lordship,
Punchlines.
the case, your lordship, so far as the prosecution case is concerned, your lordship, my the case is like this, your lordship, gist, your lordship, gist of the case is that on the date of occurrence, your lordship, the disease came out from the house of the PW2, your lordship. And while coming out, your lordship,
What
it
is
was
the point? What is the point? The
point,
has
your
to be
lordship,
that
the number one,
accepting
your lordship,
everything.
the so far as the versions of the eyewitnesses, three eyewitnesses are there, your lordship. There are some contradictions between their statements, your lordship. Number one. Number two, your lordship, they say, your lordship, that it was raining and thunderstorm, your lordship. The distance between the place of occurrence and the house of the PW2, your lordship, is around
So contradictions is not a ground for acquittal, but if the contradictions go into the root of the matter,
lordship.
show us two contradiction which goes into the root of the matter. get a
Lordship
bail
will
order.
kindly see, your lordship, if your lordship comes to PW, and secondly, your lordship, another point that I have.
Have you understood the point?
Lordship.
What we are saying?
Lordship.
Here and there will be wastage of their energy. We are not
Lordship.
going to go into minute scrutiny of what is the contradiction here, what will be the value. We are not going into this. Just show us two
Your
contradictions,
lordship will kindly.
both of which cannot exist.
Lordship, your lordship will kindly come to
One
page.
says it was night, other says it is day.
No, that is not there.
Then
That
other
that
says it is-
contradiction, but your lordship, one
Then
thing
get
is there,
argument.
your lordship. So far as the appellant number 3 is concerned, your lordship,
Hmm.
just two statements, your lordship will kindly, 2 lines, your lordship,
Yeah.
three witnesses, 2 lines I will show, your lordship.
We'll see, but what is your formulation? You have to
No,
tell the
that's
court.
what your lordship, that the act attributed, so far as your lordship will concerned, that they say, your lordship, they have seen 3 of them, your lordship.
Mr. Botaku, see, listen, please understand what we are
Lordship.
saying. What is the case? We'll come to it later.
Lordship,
When you are arguing a matter for bail, these are all convicts.
lordship,
The court has to come across something which is so grave that the court should be convinced that there is 50% chance of acquittal.
lordship,
Correct?
lordship,
And that has to appear on the face of the record.
lordship.
Correct? So first of all, if you don't make this test, if you argue a matter for one day also, there is no question.
Lordship, I understand.
Number one. So if something like that is there, show it to us in 3 minutes. Next 3 minutes, she will respond.
Lordship,
The
that's,
7th minute will dictate the order. That's the.
your lordship will kindly come to page 11 of.
What are you trying to show? Tell us
That's
that.
what I am trying to show, your lordship, that the act attributed these 3 accused persons, your lordship, these 3 appellants, your lordship.
Hmm.
There is a statement, only one statement, your lordship, and so far as the accused appellant number 3 is concerned, your lordship, no overt act is attributed to him, your lordship, except saying that one witness said that 3 are beating him, assaulting the deceased, your lordship, and the other says, your lordship, 2 is assaulting the deceased, your lordship.
It's under, it's conviction by 34.
34 is
Then there is
also
no need to say.
lordship,
That's what we are saying, Mr. Botagu.
lordship,
We don't know. If you hit the nail in the head, this is the easiest place. If
lordship,
you don't, this is the toughest place.
lordship, I
Do you want
understand.
to recalibrate your argument or you want to go ahead?
Lordship, so far as my argument is concerned, your lordship, in this particular case is concerned, your lordship, ultimately, your lordship, my entire case is, your lordship, on contradictions in the statement of the witnesses, number 1. Number 2, your lordship, the seizure, your lordship, seizure is also, your lordship, vitiated, your lordship, because, your lordship, the seizure of the weapon of attack, your lordship, that, your lordship, once a major problem with this seizure is, your seizure is made on 14th, your lordship, FR is lodged on 15th, your lordship, seizure is made on the basis of the GD entry, your lordship, and if your lordship comes to the seizure list, your lordship will find there is a reference to the police case, your lordship, which has been registered, your lordship, on the subsequent date, your lordship. Now, if that goes, your lordship, the entire case goes, your lordship, that if that seizure goes, your lordship, your lordship will get the seizure at page, your lordship, 123.
Yes.
Page 30, 123, your lordship. Here, your lordship will find, your lordship, that there is a reference to the, your lordship, the police case, your lordship. Seizure was made, your lordship, on 14th night, your lordship, on the date of occurrence, your lordship. And, your lordship, the FIR was lodged on the next date, your lordship, on the basis of which a police case was registered, your lordship. Now, your lordship, this itself vitiated the, your lordship, the seizure, your lordship. Number one. And number two, your lordship, the two witnesses, seizure witnesses, your lordship. He once says that your lordship seizure was made from the place of occurrence, and one says that your lordship seizure was made from the house of the appellant number 3, your lordship. So your lordship, their case, your lordship, is the vital part of their case, that is the seizure, your lordship, of the weapon of attack, your lordship, that will no more be there, your lordship. And in that case, your lordship, it goes to the root of the case, your lordship. That's my
Mr. Botakur, why, we'll tell you only one sentence why we will not grant the bail here.
lordship.
This is a case of eyewitness. All these are matters of circumstantial evidence.
Lordship,
You have gone completely flat on the fundamental principle.
lordship.
In the eyewitness, the only argument you can show is there are contradictions which go into the root of the matter. If you don't have that argument, we'll dismiss your bail petition. How much time you need to argue?
Lordship, my
Those are all matters of
points are these
circumstances.
three, your lordship.
Supposing 3 witnesses have seen a murder being committed.
Lordship.
Can there be an acquittal because the police made a mistake in seizure?
No, your lordship, what I am saying, your lordship, even in the statement of the two PWs, your lordship will find, your lordship, the PW2, he is one of the eyewitness. He says, your lordship, that
That's what we are asking you. Does it go into the root of the matter?
in my submission, your lordship, it will go to the root of the matter, your lordship.
Are you sure? Because if it is rejected, you are not going to get an early hearing. Be very sure about
Lordship,
it.
that-
We'll write a judgment, but we'll not write a judgment in the IA and then a detailed judgment in the appeal again. very soon.
If your
What
lordship,
you want, you decide. Don't feel intimidated.
no, your
We have
lordship,
to also be
there is
firm.
no question of feeling intimidated, your
We have
lordship,
to
because
also be firm.
I am arguing on behalf of my client, your lordship. It's my duty I am doing, your lordship.
Correct.
That's all, your
So,
lordship.
do you want to press this or get an early
Hey,
hearing?
since your lordship, if it rejects, there will be no early hearing, then your lordship, it will be better to hear the matter.
That's
your
why we
lordship.
are saying, because we cannot take note of your arguments on these subtle points and pass any observation in the bail application. If we do it this way, that way, it will be causing prejudice to your client. Therefore, these are matters where, of course, you can file an IA, no doubt about it. But we are again and again pointing it out to you because the law is very well settled on this parameter.
Lordship, I understand
So
that.
how can we go against the law? Of
Your
course,
lordship,
one way is to keep quiet, listen to it, allow you to argue the matter for a whole day and quietly pass a judgment in our chamber. But this court has not been doing this. So that is more prejudicial.
lordship,
You
I
will
know
not
your
even know
lordship.
what will be.
I know your lordship, but your lordship,
Do that.
ultimately, your lordship, since I am filing an IA, your lordship, it's my duty to point out. Your lordship may not accept. I pointed out. Your lordship says that this is the situation. Your lordship, then your lordship, matter may be fixed for hearing, because your lordship, otherwise, your lordship, we have also certain compulsions, your lordship. That's why, your lordship, we have to argue. I know, your lordship, my where I stand, your lordship, in a case
Okay,
of this
so
nature.
finally, do you want to press this idea? If you want to press, then you can argue. We'll
No, your
hear
lordship, that's what I am submitting. Your lordship. Since your lordship, if your lordship rejects my IA, then there will be no early hearing, your lordship. It's better to hear the matter, your
Why?
lordship. I will
why
not be
reject?
pressing it.
Because the arguments you are making has no value in a case where there are eyewitnesses. There are two types of prosecution case. One is direct evidence, one is circumstantial evidence. In circumstantial evidence, the chain of circumstance has to be complete. That is not necessary in case of eyewitness.
Yes.
So if you pick up a argument which is applicable in circumstantial evidence and plant it in a case where there is direct evidence, this court has no option but to reject it. That's
Yes.
what we are saying.
Lords,
Correct. So you have to argue and punch a hole on the eyewitness account of the witnesses. If you can't, then whether it is bail or final hearing, there is no scope. So if there is a faulty seizure, if the weapon has not been seized, things have not been sent to FSL, nothing matters. The motive is not a question. Only thing is if the witness was present and his or her version, ocular witness, eyewitness, his or version are reliable, that's the end of the matter. Can you meet a case to that extent in a IA? If
No,
you can
no.
do it, then we'll hear you. But if you can't do it, then it is.
lordship,
Lord-
that's why I am submitting. Your lordship may fix the matter for final disposal. Your lordship.
This is an interactive code,
Lordship.
and sometimes we are little aggressively opening our mind. The reason is to come to a proper course at the earliest.
Lords,
Otherwise, if we let things loose, then unnecessarily
lordship, I
time is
understand.
wasted and it doesn't help anyone. So in that context, I say that don't feel intimidated.
Lords,
You can argue your case. But if you don't have clarity on these things, it's not going to help you.
Lords,
Or you can say that no, even in an eyewitness case, circumstantial evidence will be primary. If that is your case, then you argue and convince us.
no, your lordship may fix the date for your lordship final disposal of the case. That's.
Is there a sense of despair in that? Or?
No, not there. I know your lordship in these situations arises in the court, your lordship. I have been appearing.
Is the paper book there?
Paper book is ready, your
Can you
lordship.
both agree on a date?
Yes, any day.
Let's do it immediately on reopening.
Lords,
Agree on a date.
Petition.
We'll give it a fixed date.
Right.
on 18th, your lordship,
18th
July.
of July.
Lords.
Okay. After arguing the IA for some time, Mr. Borthakur submits that since the primary ground of the applicant is pertaining to inherent contradictions, public discrepancies in the testimony of eyewitness account, the appeal itself be heard at an early date by keeping the IA pending. Ms. B. Bhuya, learned FPP, has not opposed the aforesaid prayer. Since the appeal has already been admitted and the paper book is also ready, we, therefore, direct the registry to list the main appeal along with the IA on 18th of July 2024 for hearing as a fixed item.
Lords.
Yes.
In fact, your lordship, initially I have not filed this IA, your lordship, an appeal was filed. Because subsequently at the
That's all right. That's all right.
request of your lordship,
You can file it.
clients, your lordship, I have to file.
The clients are entitled to ask
Lords.
questions.
That's why.
But we are also entitled to give
Lords,
the answer with.
Lords, Lords,
That's the only thing.
Lords.
Otherwise, it will be mere wasting of
Lords.
time. And sometimes what happens is the benches keep changing.
Lords.
Any observation made in the bail application unwittingly, we don't say unwittingly because judges are not supposed to. But any observation here and there, it plays in the mind of the subsequent bench.
Yes.
Lords.
So it should always be avoided. Should be avoided. Because the council will point out that earlier he made this submission.
Yes, opposition always.
They
take a
will
stand.
always point out. And it does resonate with the subsequent bench. This is a word of advice.
Lords. Deeply obliged, your lordship.
Item 30.
Yes, Mr.
My lord.
Your appearance has made me drink water. I don't know what is in store.
My lord, we have filed an appeal, which unexecuted appeal, but there is a delay of 27 days. Ground is this one, it is fault of us. Because my learned friend was decision, in the meantime, his wife got fractured and mother also did, because due to medical ground, there is a
Condone
delay.
it.
27 days only, my lord. Oh, 27 days delay.
Item 16.
Yeah, there is a delay of 7 years.
160.
Yes. Notice will go.
My lord,
We'll send notice.
Annexure A, my lord, is the copy of the judgment and order, my lord. It was passed on 25/6/2016, my lord. And the case is filed, my lord, in the year 2014, in the month of April, my lord. Almost,
Why was the delay?
my lord, delay is explained by the appellant petitioner himself, my lord, in page number 21, Annexure B. And
All right,
Page
take down
number
had Ms.
22,
P.R.A.
Annexure C.
Sultana and counsel appearing for the applicant, also had Mrs. Jahan and a PPSM appearing for the state. His IA has been filed under section 5 of the Limitations Act with a prayer to condone the delay of 5 years, 10 months
7 years.
in preferring the
then this
connected
Oh,
appeal.
defective years.
It appears that the criminal appeal has been presented from jail by the applicant appellant who was convicted under section
302.
Section 302.
IPC.
IPC and sentenced to undergo rigorous imprisonment for
Under 302 IPC, my lord.
What is the sentence? What is the sentence?
Sentence is 10 life imprisonment, my lord. Life
Sentence
imprisonment
after
with
good
fine of
offense.
rupees 10,000.
Imprisonment for life and pay fine of rupees
Fine of 10,000.
10,000. Although the delay is substantial in this case, yet considering the consequences that the applicant may have to face if the appeal is not taken up on merit, we are inclined to issue notice in this case. Issue notice returnable in 6 weeks. Since Ms. Jahan has appeared and accepted notice for respondent number 1, no formal notice is required to be sent in this case. Pursuant to the judgment of this court in the case of, what is it? What Nayak?
Deepak Nayak.
Deepak Nayak.
Deepak Nayak is only in relation to the POXO matters.
We are not inclined to issue notice to the respondent number 2 in this case. Inform and respondent number 2 in this case. Therefore, this IA shall be deemed to be ready as regards service. List after, make it 4 weeks, list after 4 weeks. In the meantime, the state may file objection if any.
No requirement to send notices in pursuance to a notification of the Guwahati High Court.
We have not sent notice.
No, not Deepak Nayak, but the notification.
Deepak Nayak leading to issuance of notification dated so and so. We are not inclined to issue notice.
Large.
For hearing item 18.
I am seeking some time, my lord, because Mr. Azad is not available, my lord. He is out of station.
When
Next week,
this
madam.
matter was called up for hearing, the learned counsel for the appellant submits that the arguing counsel is out of station and therefore the matter be posted again after 10 days. The prayer is not opposed by Ms. S. Jahan. Learned counsel, Mr. Jiuddin. And so is present, he does not have any objection in view of the above. Hearing of this appeal stands adjourned for 2 minutes. Yes.
Item 19.
Obliging.
Then Mr. Mahajan was ready to do, now he is not there. Perhaps he thought matter will reach little late. Otherwise, they were ready. This is 302 dowry debt, but convicted under 302.
But what is to be done? This is the last matter.
Last item.
One more, we passed over for the time being.
Selection other good minds.
Then next week, this is the last item.
My lord.
What are you doing?
Is coming.
The
my
last
lord.
item.
Yes, ma'am. Can be on Friday, my lord, then?
It is not possible. This
Fine.
bench will not be there next week.
My lord.
It is submitted at the bar that the learned counsel for the appellant is busy in another court. And therefore, the matter be posted again in the next week. On the request of the appellant's counsel, this appeal is directed to be listed for hearing again in the next week. Ms. S. Jahan, learned APP Assam is present for the state. Yes.
Supplementary list for hearing item.
A date may be fixed for my lord.
Next week, next week.
Obviously.
Yes.
Here also S. Roy was ready. This was that matter on the last occasion, Lordship wanted us to find out that what about material witness? The wife was not examined. The wife of the accused was not examined because of the fight.
Did you find something?
I found there, of course, the settled position is that Takhaji case, Lordship will know, Takhaji case. I've sent by email, it's there. The printout is here. Here
We'll
it is
post
said.
it tomorrow then again. We'll go through the judgment and post it tomorrow. The appellant's counsel is not present when the matter is called for hearing today. Ms. S. Jahan, learned APP Assam has furnished the copies of some judgments which will require some examination. However, since the appellant's counsel is absent today, this matter is directed to be posted again tomorrow for hearing.
There are 6 judgments that I have sent. One judgment will be very relevant where it is said
Can
there
you just
was.
mark the paragraphs and?
I've marked the paragraphs, Lordship